Good morning, ladies and gentlemen. Today will be talking about freedom of speech in Malaysia. Freedom of speech is a fundamental right under Malaysia's federal constitution, Article 10, but it is subject to significant restrictions for reasons like security, public order, and morality. Court stress that such limitation must be lawful, necessary, and proportionate. Malaysia's Human Rights Commission affirms free expression as vital to democracy while recognizing legitimate boundaries. Right to express view without undue government interference granted by Article 10(1)(a) but limited by Article 10(2). Article 10 grants speech rights but allow Parliament to impose restriction for security, mortality, and other grounds. Sedition Act 1948 criminalizes seditious tendency broadly with penalties up to 3-year imprisonment, criticized for vague terms and strict application. Communications and Multimedia Act 1998 regulates online speech. Section 233 penalizes offensive communication with unclear definition. Recent amendment in 2024 expands government power over online content. Penal Code contains provisions criminalizing insults to religion, Section 298, provocation, Section 504, and fear inciting statement, Section 505, contributing to speech restrictions. Malaysian courts adopts a cautious approach, deferring to Parliament's broad power to limit speech for national security. Federal Court upheld the Sedition Act validity in Public Prosecutor versus Azmi Sharom in 2016. Court of Appeal individuated strict liability under Section 3, Article 3 of the Sedition Act for violating due process, but federal court avoided ruling on this. Courts tend to uphold restriction relating to constitutional safeguard, for example, Article 153 on Malaya privileges. The, Se- the Sedition Act is widely used to criminalize political and social speech. The CMA is increasingly used to policy online dissent with ambitious terms like annoying or offensive. The penal codes and related censorship law impose additional constraint on speech, including bans on publications. Azim Sharom case reaffirmed Sedition Act's constitutionality. Matrimony case highlighted judicial willingness to challenge overly broad sedition law through final ruling avoided constitutional review. Recent cases show continued use of citation law against critics of royalty, religion, and government with procedural barriers to constitutional challenges. Despite government promises to reform oppressive laws, actual changes have been limited. Now, amendment to the CMA and the Online Safety Bill in 2024 expanded government control over digital media, raising concerns over censorship and privacy. Enforcement of sedition and online speech law has intensified, while book bans and other restrictions reflect growing ideological censorship. Courts have generally supported these restrictions or avoided substantive reviews. Malaysia's free speech protection coexists with broad, vague limitations that prioritize security and public overdue over liberal democratic principles. To provide balance, reforms should be focused on clear, narrowly defined laws, judicial oversight of restrictions, reappealing colonial era law inconsistent with modern rights. Clear law enforcement guidelines protecting legitimate criticism should be there. Inclusive public dialogue on free speech law should be encouraged. Meaningful reforms is essential to safeguard free expression while addressing legitimate concerns about security and social cohesion.